Hello, Attorney Christmas. You asked me to respond to this post yesterday, and I really appreciate the reaching out to me. So, in Michigan, I recommend that my clients politely decline to answer whether or not they've been drinking, citing the Fifth Amendment. I refuse to answer any questions. Politely decline to perform field sobriety tests after they have legally exited the vehicle pursuant to Pennsylvania v. Mims, and also decline to do the preliminary breath test, the roadside breath test, which is just a civil infraction here. After they are arrested, I tell them to submit to the breath or the blood test after they read what we call here in Michigan chemical test rights, but what you know as implied consent warnings, and everybody else in the other 49 states calls implied consent warnings. We call them chemical test rights here. The reason why I tell people to submit to the test is, number one, it's easier for me to challenge that in court later on in the criminal case than it is for me to challenge a search warrant that's been issued by a judge or a magistrate. Even if the search warrant is really poorly drafted or written, it's harder to challenge a search warrant than it is to challenge an officer's invocation of implied consent. Number two, we've got judges on call here in Michigan 24/7. The number of jurisdictions that don't go out and get a search warrant immediately after the client refuses to submit is, they're exceedingly rare at this point. I haven't seen one in years. So we always have a chemical test, whether it's through implied consent or if it's done pursuant to a search warrant. And last but not least, if you refuse here in Michigan, it's civil in nature. It's not criminal like some states. It's just civil, but it's a 6-point violation and a 1-year suspension for the person's first implied consent refusal. You're entitled to a hearing before our Secretary of State, but as I was reminded just a couple of weeks ago by one of these hearing officers, it doesn't really matter what the officer says because the officer only needs to make a perfunctory showing at that hearing and you lose. So it's really easy to lose at the Secretary of State. The one nice thing, I guess, is that it's kind of easy to take a circuit court appeal and get hardship restrictions after refusal, but that's a different story for a different day.